In 2025, there continues to be this one problem that people face regardless if they have a revocable trust or an irrevocable trust. So it's the biggest issue that I see time and time again. It pops up, and I'm going to explain what that is so you don't do it. All right, let's get into it. All right, so the biggest issue in 2025 related to trust planning is not always the trusts themselves. So regardless if it's a revocable trust or it's an irrevocable trust, there's this one issue that always continues to pop up. So as a quick reminder, revocable trust is typically used to avoid probate. An irrevocable trust is going to help with the state tax minimization. It's going to help with asset protection, privacy, family governance, and often they work hand in hand. A revocable will pour over to an irrevocable, or the revocable itself becomes irrevocable at some point. But the point is, you have to set these up not only the right way, but you have to implement them the right way. So the implementation phase is the number one mistake that people make. They don't implement the planning. And what I mean by that is they don't fund these trusts with assets. So the trust itself looks great. It's fantastic. But then clients don't actually move assets over. So one, why does this happen? Then two, what am I really talking about? So one, it often happens because when a client gets done with setting up their trust, they have this huge, the sense of relief. They're done with doing this big thing that's been looming over their head. The attorney often doesn't handle the implementation phase. Maybe a small part of it, but not the whole thing. If anything, at best, maybe they give a client a letter that says it's funding instructions, and clients, they have no context of this typically because they've never done it before. So the funding instructions don't really mean anything to them. Even though the attorney thinks, oh, I've handled this aspect of things because I gave this to this client, this funding instruction letter, and they should know what to do. But this is what funding means. This is what it means to move assets over. If you want to move real estate, your personal residence, or any, summer vacation home, or any other type of property to your trust, you have to deed it. You have to deed it from yourself, or, if it's owned by you and a spouse, you have to deed it from you and your spouse, or just you, to the trust. So you have to complete a new deed. You have to then go and file that deed with the county clerk. Good rule of thumb is if you do have a mortgage, to contact your mortgage lender, let them know that this is what you want to do and that you're going to be deeding this over. They may have a process that you have to go through. Maybe they want to see the trust, maybe they want to see the deed. Some lenders I've found, they don't really care, but there is this process. So that is important to go through. Often this is what an attorney might help you with. They might prepare the deed and then give it to you. That is the one aspect that sometimes happens because the attorney's involved. The other things that are missed are things such as, retitling brokerage accounts or cash accounts, checking, savings accounts in the name of the trust. I say renaming. It could be just setting up new accounts in the name of the trust. Each financial institution is a little different. So you might be able to set up new accounts in the name of the trust. You might be able to retitle current accounts that you have in your individual name or joint names to the name of the trust. Again, you have to let your financial institution know that you want to do this. This isn't something that the attorney necessarily is going to do. They could help you with it. Maybe you have questions about it, or maybe the financial institution needs to call the attorney and ask questions, but you, the client, have to take this on yourself. Sometimes it's just as easy as getting into your online portal, signing in, and making the updates. Sometimes financial institutions, again, will want to see the trust itself or specific pages from the trust, so you can remove those and send them to the financial institution. I think the other big aspect of this is a closely held business interest. So sometimes clients will already have a closely held business interest, whether it's an LLC or an S Corp, a partnership, or maybe they set one up after they've set up their trust. Point is, that closely held business interest needs to be moved over to the trust. And so how do you do that? You can do that with what's called an assignment, a transfer, and an acceptance. So you assign it and transfer as the person owning the closely held business interest to the name of the trust. The trustee then accepts it, accepts that business interest. A caveat to that, so this is something that your attorney could handle if they know that you have these closely held business interests. So it's important to tell the client or the attorney that you have these so they can help you through that process. Or if you are set one up after the fact, you could set it up in the name of the trust, but if for some reason you set it up in your own name, the attorney needs to help you with that process. The last thing to add here is that sometimes you'll have you should have an operating agreement, a partnership agreement, a shareholder agreement, whatever it is governing your closely held business interest. There might be rules in there that say that you have to go through certain formalities, get approval from the other members or partners or shareholders to be able to move your closely held business interest to a trust, okay? So those are the things to think through: real estate, cash accounts, brokerage accounts, closely held business interests. Your retirement accounts don't go in the name of the trust. They have beneficiary designations. Life insurance could be in the name of the trust. I often see people who set up ILITs, irrevocable life insurance trusts. They never, ever fund the trust with life insurance. They'll have the life insurance in their own name. So anyway, those are the things to think about. 2025, make sure that you fund your trust with the assets. Otherwise, your entire trust planning doesn't serve any purpose whatsoever.